Welcome to Oil and Gas. Let's talk about royalty payments and specifically what happens if, as an oil and gas company, as the lessee, you don't make those payments on time. So as a reminder, here's a typical oil royalty clause that you would see in Texas, very similar to what you would see in other states. The royalties to be paid by lessee are as follows. On oil, 1/8 of that produced and saved from said land, the same to be delivered at the wells or to the credit of the lessor into the pipeline to which the wells may be connected. So either you leave the oil there for the lessor or you send it in the pipeline for the buyer to pay the lessor for it. Sometimes you'll see added to that clause, or in the absence of a pipeline connection to the transporter receiving lessee's oil at the same price received by the lessee. So in other words, whatever the oil and gas company has paid for it, the lessor should receive as well. What happens, however, when the oil and gas company doesn't pay that royalty? It has control over the oil and gas pumped from the well. And what if it doesn't leave that oil for the lessor, or it doesn't give the lessor its share of the money from the revenue that the oil and gas company received by producing that oil? Well, on page 440 in your book, you see the answer. And in that case, Cannon versus Cassidy, which is from Oklahoma, 1975, the question was the lessor wanted to cancel the lease for failure to pay royalty. By the way, how big a problem would that be for the oil and gas company? That would be a huge problem because, normally, let's say we've talked about what happens when you forget to pay delay rentals and you lose a lease. That's really bad. You lose that lease, you lose whatever bonus you paid. But it would be even worse if you lost a lease for failure to pay royalty, because we know that is, if you're paying royalty, that means it's a producing well. So this is one of those oil and gas wells that you're hoping to get all of your money back, that for all the money you invested in drilling all the wells, both successful and unsuccessful. So when you have a successful well, it'd be really terrible if you lost it because of failure to pay royalty. And you can imagine that's why the lessor would love to have a lease because of failure to pay royalty. You'd say, hey, go ahead and cancel it. I'll be able to get a new lease with a new oil and gas company, probably with a much bigger royalty, because they'll know going in, this well is already producing oil and gas. So can you cancel the lease for failure to pay royalty? Well, what you see in that case is the answer is generally no. Why is that? We said if you don't pay delay rental, then the lease cancels. Well, there's two sort of answers to that. One answer is that technically the lease doesn't make payment of royalty a condition for the continued existence of the lease. So that's the reason under the text of the lease. But probably if you want to talk about what's the policy reason, well, if you have a producing lease, you're probably going to get paid. Right, so we might have a concern with some, delay rental payment that this lease may never produce any oil and gas, and so this oil and gas company could go bankrupt. You're never going to get your money. If the well is producing oil and gas, and so there's a royalty due, chances are that you're going to be able to sue that oil and gas company for the money. Because they have the money to provide that. And what we'll see is you may be able to actually just sue to get your oil back specifically. So if what was due, and that's typically true with oil, was the actual oil rather than money from the oil, then in theory, what's happened is conversion, basically theft. The oil and gas company has taken something that was yours, your 1/8 share, or perhaps a larger, lesser royalty share. It's taken what is yours and treated it as its own and taken the money for it. That's conversion. If it's conversion, that means that you can typically recover that oil, not just from the oil and gas company that took it, but also from whoever they sold it just as if somebody stole your car, you would be able to recover it even from the person that the car thief had stolen it to. All right, if what you're owed is just money, well, then you're going to be able to recover damages. Typically, you're an unsecured creditor. So that means that if a company were to go bankrupt, you might not get your money back. But you also may have the remedy in some specific situations, not in Cannon versus Cassidy, of cancellation. And you see that there were statutes described in your book and from Louisiana and North Dakota on when cancellation would be allowed. Now, royalty payment statutes vary from state to state. Sometimes you have a lien as to the oil that the oil and gas company is producing that can help you recover what you're owed in terms of the royalty. And sometimes there are special statutory interest rates prescribed by state statute, so that if your royalty payment is not made on time, well, you're going to be gaining interest. And so the longer the oil and gas company waits to pay you back, the more they will owe you. Now, interest on royalties, interest is a part of the common law as well, which is to say that normally if somebody owed you money and they didn't pay it, well, they're going to owe you interest on liquidated amounts. However much that amount was that you were owed, you're going to be owed interest on that. But as we said, some states also have special statutes that say, this is how much is owed as royalty or other proceeds after some period of failure to pay.